Okay. What's his name?
Gary Dale Lewis.
Okay. Hi, Gary.
Hello, Reggie. How are you?
Good. I'm good. Good to see you.
You too.
Wasn't on the radar a while ago. It looked like it was snowing just to the north and to the east.
Really?
Looked like it was snowing in eastern Fannin or western Fannin and eastern Grayson.
All right, this is cause number PR 17797. Style the estate of Emma Lou Johnson, deceased. Case is called today for a hearing on an application to sell real and personal property. Jim Robertson has filed a motion. There's been an objection filed by Mr. Smith on behalf of Carol Moody. Mr. Robertson, are you ready to proceed?
Ready, Judge.
Mr. Smith, are you ready?
I believe we are, Your Honor.
All right. And who else is representing a party here?
Your Honor, Michael Young and Brock Benson on behalf of Quay and Johnson, a contestant in the Emma Johnson estate.
Okay. All right, Mr. Robertson, give me a brief statement of what your motion is and why you think it's in the best interest of the estate.
Judge, we have an estate that has a little over 50 acres of land, some mobile homes, and a farmhouse, and some personal property. The problem we have is we have bills that we need to pay, and we do not have liquid assets. I think the testimony is going to show at the present time we only have about $66 in the estate account. We intend to show that we have numerous bills. One of the main bills is the ad valorem property taxes. That's a little over $3,800, and that will go delinquent January 31st if it's not paid. And of course, then there'll be penalties and interest. Additionally, if we hold on to the property, and I don't know that it could be sold before January 1st, but if we are still holding the property after January 1st of 2021, the Ms. Johnson is deceased, so we will lose the over 65 exemption. We'll also lose the homestead exemption and the frozen school taxes. So the property probably for 2021, the values are going to go down, but we know we're losing exemptions. But in any event, when we do a real estate closing, the taxes are going to be prorated to the date of closing. So every day that goes by is more property tax that both of these estates will be paying no matter what. We also have other bills. We've been paying the electric bill on the property. There is various other bills, and we filed an affidavit with an accounting, and my temporary administrator is here to explain the details of all those bills. But we do have multiple bills. We just simply do not have the cash to pay. We also have, I believe there's 4 horses on the property, which in my opinion are dissipating assets. They require care, feed. We haven't had any vet bills so far, but we could. I really see no reason to keep the horses. There was a comment that if we sold the horses, we would lose the ag. I can absolutely tell you we will not lose the ag if the horses are sold, because the tax bills have already been prepared for this year. The roll's been certified. They will get the ag for 2020. In 2021, if we sold the horses tomorrow, we still wouldn't lose the ag, because you don't have to have farm animals to get the ag. That property is capable of producing hay, and all they would have to do is file an ag exemption for the hay, and we would still get the ag exemption. So the horses need to be sold. There's miscellaneous personal property out there that needs to be taken care of. I think one of the contentions is that the property needs to be cleaned up before it's sold. And I think we can put on some evidence, Judge, to show that that's not economically feasible to do within a reasonable time frame. We think the property needs to be sold as is, where is. That will get the maximum amount of net money to both estates. We probably would spend more money cleaning up the property than what it's worth in terms of these mobile homes. And we have photographs of the mobile homes that I furnished the court.
Okay. I've got that. I've got those. Mr. Smith, what is your objection?
Your Honor, I just don't think it's in the best interest of the estate. You've heard counsel talk about trying to actually sell this property coming into the Christmas holidays or January 1st. In other words, just trying to fire sale it. And I think that that is certainly not in the best interest of the estate. One, we have, if the court will remember, in the Emma Lou Johnson case, we do have a competing will contest. So we're not even really sure who the heirs are going to be on this situation. And I understand that Mr. Coley is a temporary administrator, but we're not sure who the heirs are going to be. So I think we're putting the cart before the horse.
We're not going to distribute any assets, but is there any property there that might increase in value, or is it only going to dissipate?
Well, Your Honor, that real estate is certainly increasing in value. And the one thing that's not been mentioned is there's a number of, or at least it's been alluded to just barely, is that there's a number of mobile homes on there that I think can easily be moved. And I put in my objection that there's some dirt work that needs to be done. There's some repairs to a septic system that need to be done on the house. There are some clearing of fence rows that need to be done. My client and her siblings, who are the heirs of the Billy Johnson estate, you'll remember that's the other half of this equation. They jointly own this property, this 50-something acres. They are willing to do the work to get this thing ready to sell. I think to put this on the market right now is certainly going to just beg for a bad price, and it's just going to end up fire selling the property. Now, I see this affidavit that counsel's attached about the ad valorem taxes. My clients are prepared to pay half the ad valorem taxes right now, but I also want to say that Ms. Moody, sitting right here to my right, Judge, has been proactive in discussing with the appraisal district. And she thinks that the appraisal district is going to lower the values, maybe possibly for this year soon.
This week.
They're meeting this week.
They're meeting this week. We're waiting to hear some more about that. And then if the court will notice what's attached to my objection, the values, the appraisal district for 2021 has assessed the values way down on some of these mobile homes and on this house. So we don't think that the property taxes are going to be that big an issue going forward.
What about getting cash to pay these delinquent bills? If
Well,
we only
for
have
what?
$66 on it.
Yeah, what's interesting is they still have the Silverado pickup truck, and who's driving that thing, I don't know, but they're making a payment of $617. They need to sell that. They also have a double wide mobile home that was Emma Lou Johnson's that could be sold for some money to make it on down the road. For some reason, they needed money, but they ran all the renters off on the mobile homes who were paying rent. Now, that doesn't make any sense.
Okay.
And so what I think is I think Mr. Coley, who lives in Nebraska, Judge, and who's really not been very hands-on in this situation, just doesn't want to do it. And that's unfortunate because that's in violation of his fiduciary obligation. Ms. Moody, on the other hand, has been trying hard, and she thinks that she sees a way forward where we don't fire sale the property. She understands that at some point the property is going to get sold, but we're trying to do a reasonable job of maximizing the value. It doesn't have to turn it into a Shangri-La. She just wants to do a reasonable job of maximizing the value so that all the heirs, whoever they may be, ultimately, get the most bang for their buck out of this.
Okay. Mr. Young.
Your Honor, my client agrees that at some point this property needs to be sold, but it seems like we have a procedural issue here at minimum. I see a motion filed in the Emma Lou Johnson estate to sell property. Well, as we know, the Emma Lou Johnson estate only has an undivided 1/2 interest in this property. So are they asking the court to order in that estate that somehow this undivided 1/2 interest be sold? If I'm looking at the motion, it sounds like they want all the property to be sold. Well, that's a different estate. There's been no motion filed in this other estate. We hear the administrator in the Billy Johnson estate objecting to it. So I don't know what the procedure or authority would be to order the administrator of the Billy Johnson estate for her to sell the property as well. So I don't know how we even get there.
It's a part.
What about the divided ownership?
Judge, if I may respond, I think Mr. Young, he's in the Emma Johnson estate, not the Billy Johnson estate, and there's been no objection by Mr. Smith. But, we filed a motion to consolidate, and frankly, I don't know how else to do this, Judge. Everybody here is represented. I mean, there's nobody here that's not represented as far as I know, and Mr. Young does not represent anybody in the Billy Johnson estate, the very objection he's making. And in terms of Mr. Smith was talking about a fire sale, I think we can put on some evidence. That's why I have a realtor here.
Okay, well, yeah, we can do that. But now my concern is that if you have applied to sell some property and you're not the 100% owner, how do you pass any title to that property to a buyer?
Judge, the court has the authority to sell property. I don't have the section here. Let me show you. You have the authority to sell property to pay expenses of the estate. I'm looking at section 356.001. But again, this kind of goes back, Judge, to our motion to consolidate. And I don't know the court ever made an official ruling on that. But again, all the parties are here.
Judge, the court is certainly.
Each side has an undivided 1/2 interest.
Yep, let me finish. Okay, you go ahead, Mr. Robertson.
I'm
I'm
sorry.
just saying each side has an undivided interest, and I don't know the court ever made an official ruling on our motion to consolidate.
Okay,
But
and that is
One of the issues we brought up.
Mr. Smith.
Well, the judge, we had extensive discussions about that motion consolidate. The court decided not to consolidate it. That's why you appointed a temporary administrator for Billy Johnson and a temporary administrator for Emma Lou. He's just now trying to bring that up. I agree with Mr. Young, and that's the essence of my objection, is that they're trying to sell property they don't own, that they don't have an obligation to. It's a partition suit, I guess. I'm not trying to give Mr. Robertson legal advice, but I do think that at some point you cannot divest the Billy Johnson estate in this particular motion. It's all under the same cause number for Emma. It's not under the cause number for Billy. And that's why I made the objection, is to say, Judge,
Okay, here's what we're going to do then. I am not going to hear the motion for sale of real and personal property today. I want to brief you people on how I could even rule on such a motion if the estates are not consolidated.
That's my point, Judge. Did you ever make a ruling? Because I never got a copy of an order whether you granted or denying the consolidation. But I think that just urges our motion. It has to be consolidated. There's numerous issues why these cases should be consolidated. But in the
I
meantime, we
was
don't have,
thinking, well, I don't know that I signed an order, but I was thinking after that hearing, I had decided not to consolidate the two estates.
That's correct, Your Honor, and I believe you said that on the record, if I'm not mistaken. But
So if we don't consolidate the two estates, then how are we going to reconcile some of this property?
I don't see a way around it, Judge.
Judge, I would invite Mr. Young to comment on that. He's more the procedural guru than I am, but it's just like a normal situation whenever you have two or more owners of a piece of property. You can file a partition suit if you represent one of the owners and join everybody else in it, and then the court can make a decision.
The twist we have,
I don't
Judge, is
think
we
you have
got,
to consolidate. You don't have to consolidate these two estates in order to accomplish that.
Mr.
Judge, the
Young,
very,
let me hear from Mr. Young. Mr. Young, if we don't consolidate, how do we get rid of any of this property?
Well, I guess they can try to file a partition suit and meet the requirements of a partition suit.
Sure looks like we're running up the expenses on the estate.
seems to me
I
the simpler.
understand, Your Honor. Once again, my client's only in the position, at least on the Emma Johnson estate, as a competing contestant. So there's a whole lot of steps we have to get through before any of this gets resolved, frankly. Which, once again, ultimately, this property is going to need to be sold. But in the meantime, we have an ongoing will contest on one side, and then we have what I would consider a completely dissimilar estate on the other side, which
If the property is
I
sold,
argue
proceeds
that
are,
these cases could ever be consolidated. They're just extremely different.
Well, okay, if we have property there belonging to two estates, they're not consolidated, then who has responsibility or bears the expense of cleaning up the property to get it ready for sale?
We've offered to do it.
Judge, we've been doing it. We've offered to do it. I'm afraid there's, I think Ms. Moody's here in the state. She's understands the property. She knows what needs to be done. And I think she's willing to work with Mr. Coley to get that accomplished. So no one's saying that we won't cooperate. No one's saying that we're not going to work to try and get it prepared to sell. I think what everybody's just saying is, look, this whole thing of let's sell it before January 1st and get what we can out of it is not in the best interest of either
Judge,
estate.
Mr. Robertson, what's the problem in selling just the personal property to get money to pay expenses and to get the dilapidated mobile homes off the property and also to sell this truck so you can get some cash in the estate account to pay these bills?
let me answer those one at a time, Judge. I believe the truck may or may not have any equity. We're making $500 or $600 payments on that truck that Ms. Johnson had, and I'm not sure there's any equity. In fact, it may be upside down. The mobile homes are inhabitable. They're not rentable. We
I
cannot.
understand that, so why not just get them moved off the place without selling it?
I have a realtor here that will answer that question as to how much it would cost. I think he's going to testify be $5,000 up to move each mobile home, which we don't have the money to do. But let me address Mr. Smith's argument that we filed a motion to sell this before January 1st. We're not asking that. That's not in our motion. We're not asking for a fire sale. In fact, I think our realtor is going to say he would like to list it for $520,000. That's a very reasonable price, and he thinks he can get that within a reasonable period of time, within a couple of months. So we're not wanting a fire sale. We're not wanting to sell it before January 1 unless we get our good price. And we're going to ask the court to approve any earnest money contract, and all these parties can object if they think we're selling it too cheap.
Judge, for the record, my client thinks that there's about $10,000 owed on the truck, and she thinks that it may be worth approximately $18,000. There may be some money in that truck.
No, it's about 10 probably left. Yeah, 8. You're right.
Well, I'll need to I need some evidence, or I'll need something from an expert on that. I don't want to sell any property that's going to bring a negative value to the estate.
The truck has been sitting for months, and we're not sure of the condition of the truck. And in fact, I think we'd approached the other attorneys to sell some of the, especially the truck, and we've approached the other attorneys for months trying to get an agreement, and we've not had any agreement.
Well, the truck, I think, is Emma's.
It is.
And so that's not my
Well,
deal.
and you know, that was one of the issues about consolidating the cases, because that's the first I've heard that your side admits separate property. You know, we have community property, we have separate property. We listed the truck as our separate. I never received a copy of Ms. Johnson's inventory and appraisement. So I don't know how they've got it listed or not, but that's the first I've heard that they're claiming now that the truck is separate, not community.
We
Well,
never
it's a-
claimed it as community.
Okay, well, I don't want any unsworn testimony. I'll hear
It is.
from the attorneys, but I don't want any unsworn testimony. But,
It's not on our inventory, Judge, and I've filed the inventory. The court has a copy of it attached to the response.
I never received a copy.
has everybody got copies of Mr. Robertson's exhibits? In fact, I just got some exhibit from Mr. Smith, I guess.
Judge, those exhibits, yeah, Judge, those exhibits are, one is our inventory. The other one is the order granting temporary administration to Ms. Moody. And then the third one is duplicative. I think they're the same statements from the appraisal district as what Mr. Robertson's provided the court as well.
Well, I would like some avenue to get some cash in that estate account so we could at least pay the taxes before January 31st, rather than incur some penalty or interest. But unless we sell something, I don't know how we do that.
They have a double wide, Your Honor, that they could sell. That is not on our inventory. It's totally MLU's. They could sell it. They could sell the truck, I'm assuming, and stop the bleeding there. And we're prepared to make half the payment on the ad valorem taxes, which, by the way, may not be as much as he's represented, just simply because we think that there was going to be a revised decision on that this week.
Mr. Robertson, what's the problem with selling just the truck? Well, you said it had negative equity, you thought.
I talked to my client yesterday to get me the payoff, and I was prepared for him to testify about the payoff and the fair market value. So I haven't had a chance to talk to him. I don't believe there's much equity. In terms of the double wide mobile home, again, that's the first I've heard. They've said it's now her separate. None of those mobile homes are livable or usable, in my opinion, and I think that's going to be the opinion of the realtor, and it's going to cost money to move those mobile homes. Most of those mobile homes probably have aluminum wiring with fire hazards. There's at least one water leak, according to some of the pleadings. I'm not sure where the water leak is. They haven't been occupied in a number of months. I don't think.
Well, I'm really not talking about the others right now. They're not inhabitable. I'm really talking about the one that Mr. Smith says belongs to Emma Lou Johnson, and that you would have the ability to sell and pass title to.
I can put my realtor
Does
on
it have any value?
I can put my realtor on, Judge. I think he's going to say it has no value. I think the appraisal district may have valued that one at $1,500 or something, but it's going to have to be moved, which will cost a few thousand to have it moved. I just don't think we can sell it. I don't think we can sell any of the mobile homes to get any money. I think we'll have to pay somebody to haul them off.
Who owns the horses?
I think those are the estates, I think.
Both estates?
Yes.
Well,
Yes.
Yes.
we have some papers for the horses, but we're not sure it goes with those horses. But as far as I know, they would be community property. But what they would bring, I don't know.
Okay, well,
Judge,
Again,
as long as we're not going to lose any ag exemptions, we're fine with getting rid of the horses.
Well, there's agreeing to sell an undivided interest now that he says we can't sell without a partition suit.
Well, but you've been calling me trying to get some,
I understand.
Agreement on
Yeah.
that.
I really think the parties are to get together. We are not trying to do a fire sale. We've got a good realtor. I think we're going to get over $500,000 for this property, which I think is a really good price. And I think that may be the only reason we're holding up.
Well, we have everybody pulling in different directions today, and I'm not prepared to make a ruling on this, on the motion to sell any property because we may have a procedural issue, and I don't know that any of the parties are ready to move forward toward resolving this issue. So I'm going to leave this motion pending. I want the parties to meet. I want you to decide who owns what. And I have an inventory from Mr. Smith. I don't know if I approved one in the Emma Lou Johnson estate. I think I have.
That's correct, Judge. It's of record. And in fact, I think I gave Mr. Smith and probably Mr. Young a copy of that inventory. I don't have Ms. Johnson's inventory. I never received a copy of that.
Okay. I'm going to look again at the motion to consolidate. I think a partition suit and starting down that road is going to cost the state more money than you want to spend. There's not going to be any $500,000 left if we start a new lawsuit with 3 attorneys in it.
Well, Judge, I'll tell you, I don't think that anyone's interested. I know we had a technical discussion about the law on that, but I don't think as a practical matter, anyone's interested in getting into a partition suit. I think what we're interested in is trying to just do a reasonable amount of work to get it ready to sell. So I think Mr. Robertson and I can sit and talk about that, but I do think that there were some major procedural problems with that motion to consolidate, which the court dealt with earlier.
It sure looks like we either partition, combine, or we have an agreement. Those are the only 3 options that I see.
I understand.
Judge, if I may make one comment that, of course, Ms. Johnson is a dependent administrator, and it's my understanding she cannot do anything without the court's permission. And apparently there have been some items that have been removed, burned, destroyed. I would ask the court to remind Ms. Johnson that unless she has court permission to do all these things out there, this dirt work she wants to do or all these activities, it's our opinion she does not have authority to do that.
I think Mr. Smith can advise her that she'll need to file a motion if she wants to do that, because I'm not going to allow any estate funds to pay those things off if I have not had a motion and an order.
Yes, sir.
Okay. All right. Then I'll advise that we have another meeting and we decide how we're going to go. And I'm going to look back at these 2 files to see just what our solution might be. So after all of that, we're going to stand in recess. Everybody have a Merry Christmas.
Thank
you, Judge.
Merry Christmas.
Thank you, Merry Christmas.
Happy New Year, sir. God bless.
Well, I was gonna discourage yourself now.